This is the plaintiff, Marie Taylor. She says she paid $5,000 to the defendant for her 80th birthday party celebration. That never happened due to the pandemic, and he refuses to give her a refund. The defendant should understand the circumstances of life right now, and if he needs the judge to tell him to return her money, then so be it. That's why she's suing. This is the defendant, Daniel Akolov. He says he's happy to change the date of the party for the plaintiff, but she won't budge. It's like buying an airline ticket. If you don't get on the plane, they don't refund your money. This is the same thing. He's accused of refusing a refund.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff says she can't get the defendant to pay her back the $5,000 that she gave him for her 80th birthday. But the defendant says he's happy to have the plaintiff's party on another date, but he's not going to give her a refund. It's the case of 80 is the new lawsuit.
Thank you, Douglas.
You're welcome.
Okay, Ms. Taylor, so you were going to have a nice big 200 and something person party for your 80th and your 60th wedding anniversary, correct?
Yes.
Nice.
Yes, correct.
Okay, and Mr. Akolov, you are the owner of the venue called Floral Terrace, and that's where she was going to have her party, right?
Yes, Your Honor. You were correct with the question, yes.
And how much was that party going to cost her?
Total amount of the party would have been
$23,625
with the taxes.
Okay, so it was over $20,000. And according to the contract, which she signed when? In October of 2019, right?
Yes.
This was for her 80th birthday and the 60th wedding anniversary for 225 guests. Now, that's just the venue, correct? That's not any of the food or anything else, or is it just the venue? What is it?
Pretty much everything, including the food, the venue.
Oh, okay.
It was a buffet. It was not your typical way of doing the catering parties. It was more of a buffet.
All right. So now, Ms. Taylor, you were planning the party nice and early, a good year and a half beforehand. And then what happened?
Okay, I planned it and I put a deposit, $500 down on it, right? And then they said I have to do a payment of $1,500 for February onto August. So I have put down only 4 payments because the pandemic came. And I called them, nobody answered, right? And I went over there to a couple times, nobody was there. So when I did get in touch with them, I don't know who was the first. It was a gentleman. He said, well, if you cancel out, you have to pay us more money, at least $11,000.
So you have decided to sue now because you've decided that it's not safe for you to have a party 2 months from now.
No, it's not. And it's not safe. I'm even trying to get my shot, my vaccine. And I can't even get that. So I know it's not going to be ready for no party, not for no 200 people. Because most of my friends are old, in the 80s, you know? So it's not going to be safe for me or anybody else. So that's why I decided.
Right, but here's the thing, Mr. Akolov, she started asking for her money back in the middle of the pandemic because she's seeing the writing on the wall or whatever. Did you have any discussions with her then about how you folks could resolve this?
Yes, we actually spoke to her. We actually spoke to her attorney as well, who we gave him a couple of options. One of the options was, A, they rebook a date. B, we would offer a particular settlement if they want their money right now. Or C, just wait until the party happens. And if it doesn't happen, we refund your money in full as the way we do with everyone else.
Here's the thing, Ms. Taylor, what he's saying is right. It is fair because the problem is, and I know that we have all been beaten down by COVID so much. Every time there's a little inkling of hope, something else happens to yank it right out of our souls. I get it, Right now, where we stand is, I know that if your party were today, he'd have to refund your money because I know you can't have a 225-person party today. You are in one of the zones where you can't do that. So, of course, the venue can't say to you, oh, have a 100-person party or have a 50-person party. It can't change your contract. If when March 21st comes around, that venue cannot hold a 225-person party, which you will know from whatever the governor decides, right? Then you get all of your money back, just like he said. I am a glass half full person. I have faith that this is going to change. So I think you're kind of in, the driver's seat, but you better feel lucky. So right now, as far as this lawsuit is concerned, I can't tell them you have breached that contract. When you come to court, you have to be able to show, you can't just say, hey, I changed my mind because I don't think it's safe to have a party. My friends aren't going to come. That doesn't entitle you to a refund. You have a contract with some very specific clause. It's actually a great contract. I don't know what lawyer wrote that, but it's, it has very specific, if this, then that. If it's 75, it's 75% back to you. If it's this much before, it's this back to you. It's only the deposit. If I can't book it again, which it wouldn't be, it's only this much. There's a lot going on here, but none of it is ripe. When you go to court, cases have to be ripe. And what that means is that they're ready to be litigated. You are asking me to find that in the future, he won't be able to have the party and he will have to breach. I can't do that. I can't do that. So what I'm going to do with your lawsuit is I am going to dismiss it without prejudice. That means you can bring this lawsuit up again when it's ripe. When you know from the governor's order that he can't have a 225-person party. Now, I am sure that you are a busy man, Mr. Akalov, and I am sure that because I know that you were willing to do that before, that maybe she's actually in more of a driver's seat today as we get closer to March than she was when you and her lawyer spoke a few months ago or whatever. So perhaps you folks might want to talk to each other again and see if you can't come up with some amicable resolution that doesn't have to wait till March and you don't end up having to return the entire amount, but she doesn't end up too hurt. That's entirely up to you guys. It has nothing to do with me. As far as this litigation is concerned, I am dismissing it without prejudice. That means you're more than happy, more than able to file it again when you actually have a case, which would be once there's a governor's order saying he can't have a party for 225 people. Because once that happens, then he can't charge you for having a party for more than 225 people, because he would be in breach. Even though it's no fault of your own, you get it. A lot of venues don't get it, and they fight tooth and nail, but he gets it. If he can't perform through no fault of yours, he has to give you your whole amount back. All right. So as to this lawsuit today, it's dismissed without prejudice to you bringing it up again. Good luck, folks.
Thank you, Your Honor.
Thank you.
Marie, we'll talk.
All right. I've been trying to get in touch with y'all, and one girl I got in touch with, and she said that, they weren't doing anything, so I don't know.
No, Marie, we're not. We do it the right way, Marie. We wouldn't let you. This is not our money. It doesn't belong to us. There's just an order of things that our lawyers have us follow. So we just have to follow the protocol. And you're very important to us, and everybody likes you as a human being as well. You're very sweet. But if you can see what we have to deal with, and these other catering halls are literally not giving back a dime for anyone. We're planning to give back everybody their last dime in their due time. But it's very hard to come up with all of these funds when it just hits you in the head like a ton of bricks and you're in this position. But we are going to be doing the right thing. We're not different types of catering halls that just file bankruptcy and then go run after us in court. We're here and we'll do the right thing by you.
Well, we just heard a very interesting discussion between the two litigants in this case. That's fascinating. Mr. Akalov is obviously willing to work with the plaintiff. I hope she understands. He seems like a really nice guy. Mr. Akalov, I don't have any questions for you. You've already said everything that I would have asked you. I think the question now is to ask Ms. Taylor. Ms. Taylor, are you satisfied? You understand you filed the case too soon, so there's been no decision from the judge. Okay? All right.
All right. I'm willing to work with him. Yeah.
So congratulations. You're working with somebody pretty decent. Mr. Akalov, congratulations to you too. And
Thank
thanks.
you very much.
You decided the case based on ripeness, which refers to the readiness of a claim to be litigated and determined by a judge or jury. And certainly when a claim like the plaintiff's in this case rests on contingent future events that might or might not occur, it's not ripe. A judge really can't rule on it, a jury can't rule on it, and it's just going to have to wait for another day, right?
Right. And imagine if he had to, if everybody could just predict what was going to happen in March, he'd have to be paying out all that money all at once.
Right.
He doesn't have to pay out that money until it's clear the party can't happen in March. And it may be clear in the middle of February. There may be an order that covers that date, that comes down in the,
Sure.
but that order is not in place right now.
And we don't know what tomorrow brings. But I have to say, this guy, Mr. Akalov, what a class act.
No, yeah,
he's trying
he
to
gets
run a
it.
business through an impossible time where I'm sure he's gotten just slaughtered, because how do you run a venue like that in the midst of what's going on right now with the viral pandemic? And he's ready to refund.
And you've
the
seen
money.
how
He
many
understands
cases
the
like this
rules.
we've had where they say, no, that's an act of God, I'm not responsible. They just don't get that, hey, the act of God prevented you from doing it.
Right.
She doesn't eat the act of God. You eat the act of God.
But seriously, a class act for handling it the way he did.
And I have to tell you, I hope that she thinks about just postponing.
Right. Yeah.
Because this virus has taken enough from us.
Right.
And I am a big fan of, take it back. Your 80th birthday and your 60th wedding anniversary, that's big.
Yes.
That is big.
That's huge. I was doing a little back of the envelope math on the whole 60th wedding anniversary thing. I would have to live to be 92, I think, to get to that number. And I'm like, whoa. None of us expect to be here that long.
That's a nice,
but,
that's something worth celebrating, and something worth celebrating is worth deferring and celebrating when you can celebrate it the way you want to. But of course, that's her decision.
A tremendous blessing, though, for her.
It is a blessing.
And to be married for that long as well.
Joanne wants to know this. Hey, Harvey. A collection agency called asking for my first husband, who I haven't spoken to since 1979. I'm dumbfounded and don't know what to do. Should I return the call, ignore it, or something else? Depends on how you feel about that ex-husband. No, I'm not. I'm serious. If it's 1979, I don't see how any debt collector, first of all, has any right to anything, because the statute of limitations would have run decades ago. But no, you have no duty to contact the debt collection agency.